Okay, this is part 3 for families in the state. It's going to be a little bit shorter because we're just going to talk about a couple of different things. We won't talk too much about adoption because we could talk a long time about adoption laws and out-of-state adoptions and international adoptions. That's probably a little bit far afield. And so adoption cases typically happen after termination of rights cases. It's or when there's a voluntary adoption, someone gives their child up for adoption. You should remember all the way back to the beginning of the class when we talked about putative father registries. And so those kind of get invoked sometimes when we have adoptions because if a mother's giving her child up and says, I don't know who the father is, or, wants to give notice, that's where that putative father registry we talked about all those weeks ago can come into play. An adoption is just the legal taking on of a child as your biological child. And so when adoption happens, whether it's after a termination case and it's a step parent adoption, or whether it's a adoption where someone has given up their biological child for voluntary adoption, it is a legal miracle in a sense, because it gives the parents and the child all of the rights that biology gives them under the law. And so adopted children, when we go into wills, trusts, and estates law, adopted children are treated like biological children. They are treated the same for purposes of immigration. They are treated the same, and with some caveats to that. There are some requirements to that, but they're treated the same as biological children in almost every aspect. And that's what the process of adoption does. Now, what I also said is that it can happen after termination of rights. Termination of rights is a very serious consequence. And what a termination of rights case does is it terminates your rights to your biological, typically, child. It doesn't often happen in adoptions because there's some other legal procedures that we can do to sort of undo an adoption. So it's a little bit different. But a termination of rights case is when we terminate the rights to your child. Happens in two different situations, involuntary and voluntary. And most of the time it's involuntary. And it really depends on your state. Some states, let's say you have two people who have a child together and one of the parents is not in that child's life and the other parent says, you know what, we'd be better off without you. You don't pay support. You're not in this kid's life. You will call once every 6 months and then not show up, and then you don't give Christmas gifts, and we'd be better off if this instability was out of my child's life. Can you just sign off on terminating your rights to her? That depends on the state. And if you are in the state of Indiana, the answer to that is no. Most people think, well, if I just want to raise this kid on my own, and there's already been a determination of parentage. Now, if you are the mother to a child, and that's just because of biology, if you bear a child physically, and you are somehow unable to find out who the father is, or you claim on the birth certificate that you don't know who the father is, and so there's no father established, unless and until you legally need to, you are the child's parent solely. And typically what happens when you legally need to determine the parentage is when that mother files for benefits. So when they file for benefits like TANF or any benefits that they rely on they have for a dependent, the state can come in and say, well, you're going to have to find out who the father is. You're going to have to file a paternity lawsuit so that we can get our share out of the father. Without that happening, it is entirely illegal for a child to only have a mother on a birth certificate. And sometimes we have the situation where mom wants to just raise this child alone. Well, if dad never finds out, that can happen. But if dad does find out, then that father has the same legal rights that the mother has. That being said, they also have the same legal responsibilities, meaning child support. So there are plenty of reasons why someone might want their rights to their child terminated. And I have had people come up to me and say, hey, I am remarried and my step parent really is the parent to this child, and I want to terminate the other biological parent's rights so my step parent can adopt. And in some states, Florida, for example, the last I checked, great, go ahead and do it. As long as the kid's got a parent, we'll sign off. It's not the way that it happens in other states. And the bar in the state I practice in Indiana, is high. We don't allow that voluntary. So now we're talking about voluntary termination of rights. I'm giving up my rights because I don't want to pay child support, is what often happens. So some states will preserve that family, that blood relationship above all else. And that's typically the goal of DCS too. When DCS comes in, as we talked about a little bit ago, to respond to an allegation of abuse or neglect, their number one concern is reunification of the family. And so they have that in mind as well, but the court does too. And so even if everyone agrees in some states, we don't have this voluntary, I can just sign off on it. In other states, we do. Now, the second kind of termination of parental rights is involuntary. And that typically happens after severe abuse or severe neglect or a pattern that is unabated. So DCS gets involved. DCS gives a parenting plan, which is that here's what we think you should do. And mom and or dad fail to do any of it, and they get chance after chance after chance. Maybe they're addicts, and the parenting plan is stay sober, have X number of negative drug tests, stay employed, and they fail to do any of it. Then after a certain period of time, and that's up to the court's discretion, the court can terminate the parental rights. That can happen quicker if there's significant abuse. But if it is a typical situation where it's either neglect or it's lower level abuse, a lot of times we get in DCS messy house calls, like houses that are unfit for habitation. We're going to bend over backwards to help you keep your kid. Even in situations of addiction, many times DCS will bend over backwards to help you. And it will take years for your rights to actually be terminated. There are other situations where that doesn't happen, and it is definitely up to the judge and it's up to the caseworker when that's filed. But again, there are those administrative regulations that bear on this as well. The one thing that you should remember about termination of rights, so when it happens involuntarily, not voluntarily, because that's in states, in only certain states. So when we have this involuntary termination of rights, remember this is for abuse and neglect cases. This is a situation where many states will provide pro bono counsel to litigants because the court recognizes that in a termination of rights case, you're losing more than your money. So it's more than a civil case. You're losing the rights to your child. And the courts, the state, because it's often statutory, will provide counsel for you just like they would if you're an accused, because that's a big thing to lose. The other situation is that in termination of rights cases, they typically have an intermediate standard of proof. So if you remember, the standard of proof, the burden of proof for criminal cases is beyond a reasonable doubt. For civil cases, it is a preponderance of the evidence, right? So like 51%. I know we're not supposed to use percentages, but I use them to teach it all the time, so they make a whole lot of sense to me. In between, we have a clear and convincing evidence standard. It's higher than preponderance, but it's lower than beyond a reasonable doubt. Termination of rights cases frequently use, again, your mileage may vary by state, but termination of rights cases very frequently come with those two significant additions: counsel, and we prove it by clear and convincing evidence. Because once we terminate the rights to your child, you have no right to that child whatsoever. That child does not have to support you as you age, and they may if they are still your children when you're older. You have no right to any sort of custody or visitation. You have no responsibility to pay support, but you also have no say in any aspect of that child's life whatsoever. So we're going to give you a little bit more protection when we do that. So those are the last two concepts for children in the state. And the next time you see me, it will be via a review. So I'll see you soon.